We're talking about post-Brexit litigation today. We had given a number of talks pre-Brexit. So I think we did a Brexit talk in October, another one in December, and I think we gave another one in January because it was all that anyone was talking about at that point. At that point, we were trying to help people to get themselves together before Brexit and do the things that needed to be done before Brexit. We're now nearly 6 months down the line, so we thought it might be a good time to take stock and have a look at what has been happening, the problems that have been thrown up, the issues that people have found post-Brexit, trying to get things served, putting in defences to things, getting things struck out, and things of that nature. So it's going to be, the talk's going to be in two halves. Ella's going to give us a romp through the changes that Brexit has wrought. And then I'm going to give a couple of rants on a couple of subjects close to my heart, which are tangentially related to Brexit. So, and you know, feel free to ask me questions as I go through. I'm not going to be listening because I'm going to be too busy on the familiar train tracks of ranting that I've prepared. But I'll hand over to Ella for the time being for the what has Brexit changed parts.
Thanks, Sarah. In fact, I'm going to start very quickly with what hasn't changed, because there are some things that you'll be glad to know haven't. Some EU law has been retained. That is not an entirely straightforward, working out what EU law has been retained is really not entirely straightforward. Sections 2 to 4 of the withdrawal agreement established 3 broad categories of EU law that were retained. And the idea is that there was supposed to be a sort of snapshot of EU law as it applied in the UK or in England and Wales at the time of the exit. So some obvious things that will have been retained: any UK domestic law implementing, for example, EU directives, EU law that applied directly without the need for implementation, so a good example of that is the GDPR, but not, of course, directives, which required separate legislation to be implemented. So unless there was separate domestic legislation implementing those directives, they are now gone. That said, it's not as easy as that because there have already been some revocations, some amendments. I'm afraid you really do need to look at each law on a sort of case-by-case basis, undertake your statutory analysis and try to work out whether or not it still applies as it did. But applicable law, still governed by Rome II, so that's nice and straightforward. We don't need to relook at the rules for applicable law. Article 18 we've set out there is of particular note, and what that says is that the person having suffered damage may bring his or her claim directly against the insurer or the person liable to provide compensation if the law applicable to the non-contractual obligation or the law applicable to the insurance contract so provides. So effectively, if the applicable law says that you can bring a cause of action directly against the insurer, you can. But you don't need to worry about applicable law, that it works as it always has done. And again, English proceedings, still governed by English procedural rules, as they always have been, as long as you can work out what's procedural and what's substance. But quite a lot has changed. So as anyone who's attended any of our previous webinars on this topic really should know, and indeed anyone practicing in this area by now, recast Brussels only applies in respect of claims issued prior to the 1st of January 2021, but also to closely connected claims. So those would be anchored claims or Part 20 claims. So it is still possible to join in parties to claims that were issued before the 1st of January 2021 for the purposes of, for example, Part 20 claims, or if you've got anchor defendants. But if the proceedings aren't on foot at all, I'm afraid it's too late. What that does also mean usefully is that any proceedings that were issued prior to the 1st of January 2021, because recast Brussels regulation still applies, that will prevent parallel proceedings being brought in EU member states. So that's a useful protection that applies to those claims, but again, won't going forward to anybody who missed that 1st of January 2021 deadline. So what that means is that claims issued since exit day, or since 1st of January 2021, are governed by the common law rules. And they operate in the same way as claims effectively anywhere else in the world. And what that means is that litigants must first bring themselves within the gateways to be found in Practice Direction 6B, so the gateways in respect of service out of the jurisdiction. But even if you can get yourselves into one of those gateways, and we know that, of course, is not entirely straightforward, given what's happening in the Brownlee litigation, that's a topic that could fill its own webinar on its own. Even if you get over all of that, you then have to demonstrate that England and Wales is the form conveniens. So here we have some examples of some of the gateways in Practice Direction 6b. The first of those is anchor defendants, and this is subparagraph 3 of 3.1 paragraph of Practice Direction 6b. And what it says is that a claim is made against a person, the defendant, on whom the claim has been or will be served, otherwise than in reliance on this paragraph. And there is between the claimant and the defendant a real issue which it is reasonable for the court to try, and the claimant wishes to serve the claim form on another person who is a necessary or proper party to that claim. So that is where you have a defendant that you've already been able to serve, and you want to be able to serve somebody else who is a necessary and proper person to join into that claim. Another gateway is if the contract is formed within the jurisdiction. So that, of course, means going back and looking at all of those law school cases that we all learned once upon a time about how contracts are formed, when they're formed, where they're formed. Or, hopefully more straightforwardly, if the contract is governed by English law. And then in respect of tort cases, where the damage is sustained within the jurisdiction. So that's subparagraph 9, paragraph 3.1 of Practice Direction 6b, which is a claim is made in tort where A, damage was sustained or will be sustained within the jurisdiction. So that gets us into all those legal niceties about where damage will be sustained or has been sustained.
Ella, can I stop you there? We've got a question in, and this seems a good time, as good a time as any to raise it. So the question is, can injury claims against a tour operator ever be brought under the package travel regulations, fall under Article 18 of Rome 2, or do they fall outside because they're breach of contract claims? So I think what the questioner is asking is there a direct right of action against the insurer of a tour operator under Article 18 of Rome 2? The package travel regulations are a peculiar creature. They imply turns into a contract, so their claims made under the package travel regulations are contractual claims. So they would not be tortious claims unless you can bring a parallel claim in tort. So you might have a claim in negligence and in contract as well under the regulations. But the reason we use the package travel regulations is because they impose a sort of vicarious liability on the tour operator for the torts of other people. So, for example, if you were looking at a claim about someone who falls down the stairs in a Spanish hotel, let's say, you could sue your tour operator under the package travel regulations, and they would be liable for the acts and omissions of the hotel, and they wouldn't have an independent subcontractor defence, which is what the regulations do. So you can sue your tour operator, and that, Ella, I think, if you're looking at suing your tour operator, would be a contractual claim, and you would be looking at contract formation, which is what you've just been talking about. Yeah. You know, where was the contract formed? Is it governed by a choice of jurisdiction clause? And more than likely, it's going to be English most of the time, most of the contracts that we see. If, however, you're not suing your tour operator for one reason or another, and you want to bring a direct right of action under Article 18 of Rome 2, I can't really see a situation where you would do that in parallel with the package travel regulations, because you'd be looking, wouldn't you, at suing the hotel's insurer here. Let's think that through. So let's say you've fallen down the stairs in a Spanish hotel, you want to sue the insurer of the hotel directly. Could you sue them directly? You'd have to look at whether Spanish law gives a direct right of action, wouldn't you?
Yeah, you would.
And then, so if, let's say Spanish law does, because it does, provide a direct right of action, then in that case, you're looking at suing the insurer directly for something that's happened in Spain under Spanish law. Could you, though, then get jurisdiction over the Spanish insurer? I guess that's what you're talking about now, isn't it? Yeah, exactly. And I think that's the thing, we talked about Rome 2 at the beginning, but actually it's a step that sort of comes in later. Your first question is always, can you
do you have jurisdiction? Are you able to sue this person in the jurisdiction at all? And then you worry about applicable law.
Right.
And I think
they're two distinct things, aren't they? It's quite important to keep them totally distinct in your mind.
Yeah, definitely. And I would think to deal with them in that order as well. And generally also package travel claims, I think, probably largely come under our first slide of what hasn't changed, because assuming that you have an English domiciled tour operator, there's no question about where the contract was formed, no question about jurisdiction, which is the case in almost all of the package travel regulation cases I think that I've ever done. Those are just domestic cases, effectively. They do relate to something that happened abroad, but they're not affected by Brexit in any real way, because you are still suing an English defendant in the English courts pursuant to an English contract. It's just that you have to worry about the local standards issue. But they are largely unaffected by everything that we're talking about today.
Sure. I hope that answers that.
So yes, jurisdiction. So yeah, first of all, you have to establish that you can serve out of the jurisdiction and that you come within one of those CPR gateways. But that is not the end of the story, because you also have to establish that that England and Wales is the forum conveniens, that it is the appropriate forum for the claim to be tried in. That again is a sort of topic that we could probably fill an entire, if not a whole day's worth of webinars on. I'm afraid it requires going back to all of the case law, but there are some handy summaries in some of the recent briefings that we've put out, some of the recent cases, so I would direct anyone who's interested in that to those. But some of the factors that are going to be taken into account: the domicile of the parties, the location of the harmful event, the applicable law, and practical considerations. So practical considerations about how easy it is to have a trial in one forum or the other, which I suppose might be further impacted by the way the world is at the moment in our pandemic-y times. But there are also changes in respect of service, and here there is a trap for the unwary that it is worth highlighting. Whereas we are all used to, with, for example, Odenbright type claims, serving on UK handling agents, you can't do that anymore. Service must now be effected on the defendant or nominated solicitors, not on insurers, UK handling agents. Service on the handling agents will be defective and will be set aside, and claims will be struck out. And while I'm on service, I think we've had a question in advance about service that Sarah's going to answer.
Yeah, in fact, we've had a number of people raise this question, which is quite interesting. So the question is this: what box do you tick on the new N510 form for service out of the jurisdiction without permission of the courts when you're looking at, and then insert type of claim here? So we've had different questions about different types of claim. The first point to make is that there is a new form N5110. So do not use the old form or it will be defective. So that's the first thing to bear in mind when you're serving proceedings. Don't use old forms from old precedents that you've used before. So there's a new N510 and it's got various different boxes that you can tick. And this is for serving proceedings which have a kind of foreign where you can do it without needing to apply for the court's permission. Part 1 relates to serving in other parts of the UK. Part 2 relates to service outside of the UK. And it talks about, is it a consumer contract? Because we know that there's a carve out for jurisdiction for consumer contracts. Is it a Hague Convention case? So the Hague Convention applies to really commercial matters, nothing that we need to worry about too much where we're looking at personal injury claims. Is there an exclusive jurisdiction clause? Or does the court have the power to determine the case under another enactment? And you're looking at things like the bankruptcy petitions, things like that, although actually bankruptcy petitions aren't covered, so not a great example, but other enactments. And the answer to that is, if you're looking at making one of the types of claims that we generally look at, other than clinical negligence cases, you're not going to come within any of the boxes on that form because the Hague Convention doesn't relate to personal injury claims, and unless there's an exclusive jurisdiction clause in the contract, which is slightly unusual in the type of cases that we handle, you're not going to be able to bring yourself within any of those boxes. the effect of that is that you can't use the form N510 for things like direct claims against insurers, motor claims and other claims against insurers. So actually you need the permission of the court. It's really as simple as that, that you can't use the form for lots of the cases that we handle, other than clinical negligence, as I say, because clinical negligence will probably be a consumer contract claim. So you can tick that box on the form. You can get away without having to seek the permission of the court to serve outside the jurisdiction. In other cases, though, you're going to have to get the court's permission to serve on insurers outside, because you can't serve on UK handling agents anymore. And we really cannot stress this enough. I've been involved in a number of cases where service has already been struck out on the basis of defective service. And that's pretty serious matter, because if your service is struck out and you haven't served within time and your proceedings, the lifetime of your claim form has expired, you're going to miss your pre-Brexit jurisdiction in the way that Ella was describing. It's pretty brutal. If you've served before the turn of the year, if you've issued before the turn of the year, you've got another month to serve your foreign entity. If you attempt to serve it on UK handling agents, or if you serve it on the wrong solicitors, for example, sometimes you get a situation where solicitors, a particular firm is usually instructed to accept service on behalf of an insurer, but actually in this case they weren't. That service is going to be defective as well. And that just leaves you with a month to get it done or apply for an extension. And the fact that you've wrongly served on UK handling agents is not going to be a good reason to allow you an extension of time to go away and serve properly, because it's something that you ought to have known, because we have been telling you about it for a bit. So the answer to the questions, you know, what box do you tick on the new N510, is that you may not have a box to tick on the new N510. You may be in a situation where actually you need the court's permission. So Ella, I don't know about you, but I'm expecting to see a lot of applications for the court's permission to serve outside the jurisdiction in future, and jurisdictional challenges as well.
Yeah. And I think it's worth also pointing out that questions of service it's an area where the courts are just very, very strict. You know, we've got quite used to now being able to get relief from sanctions for missed deadlines and all sorts of other circumstances. I'm not saying you should, but there is a process for that. But applications for extensions of time or applications relating to defective service is an area where the courts just take an incredibly hard line.
Yeah, and actually a lot of people don't take those points. I've seen people get away with this a bit, that, you know, claimants are making applications to extend the lifetime of a claim form so that they can serve it. Defendants not challenging that service, but actually if they were to challenge the applications for extension of time, they'd be successful. So I've seen quite a lot of defendants missing out on complete defences to things where they could say, well, they should never have got that extension in the first place, because you have to show that you've tried quite hard to serve it within the 6-month lifetime. And if you've just done nothing for 6 months, you shouldn't get an extension. We've got another question. Suing a Spanish insurer, serving on the defendant solicitors in the UK, you still need the court's permission to serve. You won't then, because you're serving within the UK on nominated solicitors. So you either serve the defendant itself within England and Wales, or you serve their nominated solicitors. As long as they have nominated solicitors, you can serve on those people, and that's fine. You don't need the court's permission. It's only where you're having to serve outside because they haven't nominated.
Yeah, and that's where your point about don't just assume that solicitors have been nominated because you dealt with them before is important. Yeah. Check that you have that nomination. So moving on then to enforcement. And again, claims issued prior to the 1st of January 2021, nice and straightforward. They can still be enforced via the recast Brussels mechanism. But claims issued after that date are not subject to that mechanism. So you are effectively then thrown back on looking at local enforcement rules and working out whether or not you can enforce in particular countries based on their own enforcement mechanisms. You don't have the benefit anymore of sort of an EU-wide enforcement scheme. So judgments given in respect of claims issued before that date are still enforceable in the courts of the EU. That's nice and straightforward. but judgments given in respect of other claims are not. And that means that there are currently no enforcement provisions in respect of EU judgments. Many of you know that obviously the UK made an application last year to be allowed to join the Lugano Convention. That application is largely supported by the EFTA states, but the EU Commission has recommended that the UK should not be allowed to join. A slightly surprising decision earlier this month. It was being widely reported quite confidently by some people that we were going to get the green light, but the EU Commission has said no. The view they've effectively taken is that the Lugano Convention is a flanking mechanism, a flanking measure to the internal market. And they've said it relates to the EU and EFTA and EEA context of the relationship between the EU and countries in EFTA or the EEA. We said we didn't want to be in those. We didn't want any connection to the internal market. We wanted to be completely independent. And the Commission says that's fine, but that means that you are a third country without a special link to the internal market. And without that special link to the internal market, you're basically no different to any other third country. Forget the last few decades, you are now effectively just a third country. And without a connection to the internal market, there's no reason that you should be given access to this judicial cooperation that other countries don't have. So that's where we are on that. I know Sarah has thoughts she would like to express, and I'm also going to hand over to her generally on what is likely to change going forward, and a bit of crystal ball gazing now that I've taken you on a bit of a gallop through what has or hasn't changed.
Yeah, thank you. I mean, what a load of a codswallop, honestly. Not you, the EU. Anyway, I will rant about that in just a moment. We've got a couple of questions. Let's have a look at those before I move on to my rant. I'm just limbering up for my rant, really. So, if a consumer would like to sue a German trader for €1,000, what court, what forms? If you're a consumer, then you're going to fall within the consumer exception. So if you've got a consumer, then there is a carve out in the amended 1982 Act under whatever regulations they are. Anyway, so there is a box on the form N510 which says I've got a consumer claim, so I am entitled to bring my claim within the courts of England and Wales without seeking the court's permission to serve outside. So you use the usual form, and I guess it would be a small claim, and you serve the German trader in Germany at their registered address or at their known address. And you can do that without getting the permission of the court because you've got a consumer contract, assuming that it was formed within England and Wales. But you'd need to look at formation of contract, which is a thing that I haven't looked at for about 30 years now. So as Ella says, we're all going to be brushing off our contract law books. But it would, in a consumer case, you're looking at something that is very much more aligned to what it was than some of the stuff that's changed a lot more. So that is sort of as normal. Okay, so if UK solicitors agree to accept service in the UK on behalf of the defendant foreign insurer, where a direct right of action applies, you still need to have the documents translated, which you would need to do if you were serving outside the jurisdiction to ensure proper service. Do you need the agreement of the UK nominated solicitors not to have to translate? No, you don't have to translate because you're serving within the jurisdiction. So you don't have to translate, and you don't have to have their agreement not to have to translate. So you can do that just on the nominated solicitors in the usual way without having to spend, you know, thousands and thousands of pounds on translating the documents. Is one of the advantages of it. Okay, next question. So if, say, an Austrian consumer gets a CCJ against a UK travel company in the Austrian courts, how hard is it for the Austrian consumer to enforce that in practice? I don't know the answer to that because I don't really get involved with enforcement. And the reason I don't get involved with enforcement is because it's just been easy peasy so far. So you've either got EU cases, which so far for the entirety of my practice, it's been really easy to enforce, or you've got rest of the world cases, which for the entirety of my practice has been really hard to enforce. So you have to do a cost-benefit analysis on enforcement in relation to those. But where you've already got a case up and running, So if it's been issued pre-Brexit day, don't forget that anything that's issued before the 1st of January of this year is going to be governed by the old rules. So I can kind of wriggle out of answering that question a bit, because if you've already got your judgment, then the old rules are going to apply, and it's going to be very easy to enforce in practice, because the old recast Brussels reciprocal rules are going to apply to that case, because you've already had your case up and running, you've got your judgment, you can still enforce it. And the same goes the other way around, where if you've got an English claimant who's got a judgment against an Austrian defendant, as long as you've started your proceedings pre-Brexit day, then you're going to be able to enforce under the old rules. And that is why it was so important. And that's why we had so many webinars on this subject, that people started their claims before the end of the year, because it made enforcement much easier. Now, after the end of the year, so anything issued on or after the 1st of January of this year, it's going to depend on the arrangements of that foreign court, or in your question, of the English court. So do the English courts enforce Austrian judgments? I imagine the answer to that is probably yes, but I don't know. And we're all going to be going on a learning experience together with respect to that. There's lots of bilateral treaties already in place. So, for example, we had an old one with Norway, which we've breathed some life into, because we're not joining Legault, which I'll be ranting about in just a moment. So we've got a reciprocal agreement with Norway, which kind of works as if we were party to Legault. We've got some reciprocal agreements with various nations. Some countries are easier than others. I can only tell you from an English lawyer's perspective, trying to enforce abroad, because I've never tried to enforce a foreign judgment in England, but I imagine we'll be doing a lot more of that in the months and years to come. But certainly you get with some nations, I mean, already Greek courts were very unwilling to enforce English judgments, even though we were subject to recast Brussels, because they don't like our cost rules. So there's already been a couple of judgments from Greek courts saying, well, we'll enforce the damages, but we're not enforcing the costs. And that shouldn't happen under recast Brussels, but it did. And I imagine that some of those countries that are unhappy about enforcing our rules and our judgments are going to be even more unhappy about enforcing them now. It's going to take a lot longer. So I think enforcement is a really live and important issue, but we're not going to see how it's going to work for a little while, because everyone's issued all their claims in a big rush prior to exit day. So I don't feel like I've answered that question terribly well, but I think the answer to that is it depends. But for the time being, you're going to be okay if you've issued pre-Brexit, or if you've got your judgment pre-Brexit. Okay, so I've been working on the basis that permission will not be required to serve claims brought under recast Brussels. Looking at the legislation as a no, you haven't misunderstood us here. If you've issued before the 31st of December, you're going to be okay. If you haven't, we're talking about the situation going forward in relation to what needs to be done afterwards. So you haven't misunderstood us. Okay, good. And last one, just to check, if I have a claim for vehicle damage and policy excess arising from an RTA which needs to be served outside, but it was issued, this is the same question, do I need the court's permission to serve? No, you won't, but you can use an old form for that. Don't use the new form for that, because you've got a pre-Brexit case. So you're using the old 5110, not the new one. You're not using the one that I've just been quoting from, because that's for things that are issued after Brexit Day. We're talking about things issued after Brexit Day. Before Brexit Day, you're going to be absolutely fine. You use the old form and you tick the box that you would usually tick. So I think those questions are related. Okay, I'm going to stop answering questions. I'm going to start ranting. There we go. Okay, so enforcement. What is likely to change? Enforcement. We've talked about this a little bit. Will the UK be allowed to accede to the Lugano Convention? We asked to accede to the Lugano Convention. Of course, you'll all know that this is the EFTA. This is the EFTA equivalent of recast Brussels. So it's a pretty old one. It was the equivalent of Brussels, but for the interesting countries, Iceland, Norway, and Switzerland, who kind of fall into their own category. So it was kind of Brussels 1, slightly different. So it still has all the problems of Brussels 1. For example, the Italian torpedo is possible under the Lugano Convention, and it's not so strong on jurisdiction clauses. But it was really handy, and it enables Iceland, Norway and Switzerland to have judicial cooperation between each other. We applied to accede to it, as Ella said a year ago. It's taken the Commission a year to decide that they don't want us, and the EU has vetoed us effectively. The other nations, the individual nations, so Iceland, Norway and Switzerland, want us to accede to it. We want to accede to it, but the EU doesn't want us to accede to it. And the reason that they gave, as Ella says, is that we're not special anymore. And I'm afraid it looks like a case of sour grapes. To me. So the Commission is saying, well, you're not a special country with special links to us. We don't love you anymore. We don't want to enter into a convention with you unless you enter into conventions with us to do with fish, which seems to be something of an obsession for the Commission. So they've recommended to the Council and Parliament that we shouldn't be allowed to accede. There is still the possibility that the Council may say, well, thank you for your recommendation, that's very interesting, but actually we're going to do a sensible thing now and allow them to accede to the convention because that enables us to cooperate with each other. It's very unlikely that's going to happen. The mood music coming out of Europe is very much, if you don't agree with us on fish and beef, we're not going to agree with you on judicial cooperation. I'm afraid that just seems to me to be a really petty way of approaching what is quite an important issue. And it's not just important from a point of view of big companies arguing with each other and where do you, what court has jurisdiction over them and how do you enforce judgments. It's important from a point of view of people who've been pretty badly injured and who need to get compensation and who now cannot access meaningful justice because there's no convention in place, and everyone agrees that there ought to be some cooperation between the nations. What seems to be happening is that the Commission thinks that if they don't allow us to accede to the Lugano Convention, that commercial entities, companies, will put jurisdiction clauses in their contractual agreements which provide for the courts of the EU to have jurisdiction as opposed to the courts of England and Wales. So I think they're kind of hoping for a bit of a judicial land grab because they've said, well, look, you can't join the Lugano Convention, but just use the Hague Convention rules. But actually that doesn't help us as PI practitioners because the Hague Convention doesn't apply to PI. So I think what they're hoping for from not allowing us to accede to Lugano is for commercial entities to start providing for the courts of Europe to have jurisdiction as opposed to the courts of England and Wales to have jurisdiction. I think their hope is that once they've got people putting those clauses into their standard terms and conditions, that will just become a default setting. So it means that they will, the courts of Paris or Frankfurt or somewhere like Brussels, will have jurisdiction over claims that they wouldn't normally have jurisdiction over because England was a very popular jurisdiction of choice for companies worldwide. Whether or not that's going to work is anyone's guess. It may be that once they've had a year or so of that and seen how it pans out, and once they've persuaded people to change their standard terms and conditions to make England and Wales less popular, it may be that they'll relent, they'll allow us to accede to the Lugano Convention. I know that Tom Yarrow's view, and I regard Tom Yarrow as being almost godlike in his knowledge of all things Brexity, because he knows what he's doing, unlike the rest of us who are all sort of flailing around in the dark with no idea what's going on. And the reason for that, of course, is that he worked in the Brexit department. Tom Yarrow's view is that until we've got an agreement on fish, there's not going to be an agreement on courts. But it feels difficult to accept that that can possibly be the case because it seems to me the two things are completely and wholly unlinked. But from what the Commission is saying, they don't view it that way. I just have very strong views about this, which I probably oughtn't to express for reasons of international comity. I see we've got another question, so I'll zip it for now on Lugano, but I will come back to it. If a claim is issued before exit day, but named the incorrect defendant, interesting. Will he or she still be able to amend the claim form pre-service and maintain English jurisdiction on the claim? That's a really interesting question. It's probably an abuse. I've had a case where the incorrect defendant was named because somebody, a different one of a company, a group of companies was named. And the advice I gave was, well, amend it and see what happens, because you don't really have a choice. And if it's part of the same group of companies, if there's some reason for the slip, then I can see the court saying, well, that's fine. You can amend a claim form pre-service, as you know, without the permission of the court. And it's still a pre-exit day claim because it's been issued pre-exit, and there was a good reason for it. If, however, it looks in court as if there's some jiggery pokery going on, where you've got the wrong defendant completely, and now you're going against somebody else completely, in respect of a different course of action, for example, then I can see the court saying, well, that's an abuse. You can't do that because you're depriving them of a jurisdictional defence. But these are the types of questions, that's a really interesting one, these are the types of questions that we're going to be grappling with in the next sort of 6 months, I think. Can fishing dispute claims be brought onto Legault? Not unless someone falls off a vessel is the answer to that. It's not, the two things are completely unrelated. Now, I've just had a message from Tom saying it's not entirely his. The sainted Tom is listening to us, Ella. This is even more worrying than I'm nervous now. Tom says, my view is when the EU have weighed out how much market share they've nicked against how mad they've made their citizens, they'll have a rethink. And then he makes an appalling pun, which I will not bother you with. Terrible. Yeah, no, I mean, I think that's right. I think for the time being, the EU is unlikely to allow us to accede to Legault. I've now come round to Tom's way of thinking, having said to him in the past, well, don't be ridiculous, they surely wouldn't be that petty. I've now been proven to be wrong, they are precisely that petty. But it may be that they will think better of it in a year or two's time. But that's what we're looking at. That's the type of time frame we're looking at. So for what it's worth, my own view is you either issued before Brexit Day or you hunker down and don't issue. The worst of all possible worlds is issuing now after Brexit Day and before we've got anything else in place, because you may not be able to enforce anything that any judgment that you get, or it'd be more difficult to enforce. So if you can wait would be my advice. Now, something else on the chat, is that a question? Yes. Honestly, Will, question and answer, chat function. Question, I mean, I know you've done this before. Right, you touched on the gateways earlier. What's the current position in respect of damage sustained in the jurisdiction gateway? Isn't that what Brownlee is all about? Yes, it is. And depending on where you look in the last decade of the Brownlee litigation, the answer to that pops up every couple of years. We're waiting at the moment for the Supreme Court judgment in Brownlee. I think it was February, wasn't it, that they heard Brownlee, and we're now waiting on the judgment. At the moment, indirect damage is sufficient. That's the latest Brownlee judgment. It may be that will change after the Supreme Court, and the distinction is this: if you're, let's say you're injured in Spain, your direct damage is sustained in Spain because that's where the injury happens. But the indirect damage can be sustained within England and Wales because that's loss of earnings, care, ongoing medical treatment, stuff like that. Indirect damage is enough for the courts of England and Wales to take jurisdiction. You get through the gateway on that. Whether or not it's going to give you forum convenience is another matter. The rules have, since Brownlee was first considered, been changed. So indirect damage for our purposes is going to be enough in almost all cases that aren't time barred, because they changed yonks ago to say that indirect damage is enough. So Brownlee, to some extent, is of academic interest, really. Paul McClory is just talking nonsense again. I don't know why I bother reading him. Right, so will bilateral treaties be concluded? Currently not, because that's within the competence of the EU, and they're telling their nations that they can't do it because they're negotiating on behalf of their nations in respect of the Lugano. So no bilateral treaties, probably. It really is Lugano or bust by the looks of it. And as I say, unlikely to be solved within the next year. So that's my rant on the Lugano Convention. Let me answer this question and then I'll give you my rant on Vanook. Is there a direct, I don't know the answer to that, I would have thought so, yeah. Sorry, the question is there a direct treaty with the Republic of Ireland? The answer to that is I haven't got a clue. It may be that Tom will have the answer to that because he knows everything. We've got direct treaties on everything else with the Republic of Ireland, so I'd be really surprised if we don't. We've got things like reciprocal voting rights and stuff like that. So I would have thought so is the answer, but I would have to check that. Sorry, I've got distracted by Paul McClure again. I really should, is there a way of, can you mute him? We can mute him. Somebody mute Paul, brilliant, brilliant. I love Zoom. Okay, my Vnuk rant. Now, you may have seen my Vnuk rant in written form in the New Law Journal, which I wrote an article with Chris Deacon of Stewart's about this. And it's a wide-ranging rant. I've only got sort of 5 minutes to give it now that I've ranted so much about Legault. But the Vnuk liability, it's a pretty niche area, let's be honest about this. It's pretty niche for me to get so upset about. But it seems to me that this is an indicator of how the current government is approaching matters relating to our exits from the EU and the legislation that they propose to put in place afterwards. And so it's quite important as an indicator of what I think is going to happen going forward under the current political regime. And people who know me will know that I've got strong views about everything, including politics, but I don't think that lawyers should stick their noses into politics unless politicians stick their noses into law, in which case we can snap them off. And that is precisely what's happened with the Vnuk liability issue. So you may have seen that, a month or so ago, that's 6 weeks ago, the government said that it was going to bin Vnuk liability. Now, that's not really something that most people know anything about, but it hit the headlines because the government said, here is a bit of European case law, which is really, really expensive for motor insurers. So it's really expensive for people who are paying insurance premiums. And we're going to bin it now that we're out of the EU, which is a great victory for consumers, for drivers, and for British people. And that was how it was packaged. We're going to bin, and that I'm not paraphrasing, that's the word they use, we're going to bin Vnuk liability. And it's a great result, and it's one of the great things about leaving the EU. I've got views about this. I disagree with practically everything that was said in the press communique. First of all, binning something is not a helpful way to describe what you're going to do with a case or legislation. Secondly, almost nobody knows what Vnuk liability is. So it's kind of, they were saying we're going to save motorists money, but the figures that they use to underpin that assertion are dubious, in my view. Anyway, what does Vnuk do? I've said it's a pretty niche area. Vnuk is a case that was decided by the Court of Justice of the European Union, and the Court of Justice of the European Union looked at this chap who'd been injured, I think hay baling on a tractor and trailer in a barn. Came before the court in 2013, so quite some time ago, and before even Brexit was a twinkle in the eye of the British voter. The court held that the motor directives, which provide for compulsory insurance, apply to the normal use of vehicles, even when they're on private land. And that's important because our Road Traffic Act does not provide for compulsory motor insurance for vehicles on private land. It only applies to public roads. So our domestic legislation doesn't implement the motor directives properly, because the motor directives say you have to have compulsory insurance that applies to both public roads and private land. We've not implemented that because we've only said you've got to have compulsory insurance in public roads. So, of course, you would expect that having had that decision from the Court of Justice in 2013, we would then amend our Road Traffic Act so that it did comply with the motor directives. Well, you would expect that if you didn't know anything about the way that the English legislature works. So, for example, the direct right of action implementation regulations never complied with the motor directives and still don't. The Road Traffic Act was not amended in response to Vnuk. And the consequence of that was that the English courts had to try and interpret the Road Traffic Act as if it were consistent with the directive, whilst also knowing that it wasn't in fact consistent with the directive. So we had a slew of cases in which the courts bent over backwards to try and find for claimants in circumstances in which the actual wording of the Act didn't seem to suggest that they would be able to find for claimants. The first one of those was Wastrel, which is a burger van. And the court found in Wastrel that the Road Traffic Act was engaged. So it was subject to compulsory insurance in that case. Lewington then, a dumper truck was a vehicle within the meaning of, there we are, Lewington in 2017, a dumper truck was a vehicle within the meaning of the Act which needed to be insured. And then there was Road Peace and Secretary of State for Transport, in which the charity Road Peace attempted to force the Secretary of State to amend the Road Traffic Act. And they succeeded in the sense that the court declared that the Road Traffic Act was not compliant, but said, well, there's no remedy for that except that you bring a Frankovich-style challenge in every case. So in 2013, the Court of Justice had said the motor directives say that something in particular needs to happen, and we hadn't done it. We didn't amend the Act in response to that. In 2017, the courts said the domestic legislation does not comply with the motor directive and it needs to be amended. And what did we do in response to that? Did we amend the Road Traffic Act? No, we did not amend the Road Traffic Act. And then there were further cases in which the courts attempted to square the circle. So the first one is Lewis and MIB, in which the claimant was injured on private land. This was someone who was actually driven down by, I think, a farmer on private land, on a farm. And Lewis sued the MIB because the farmer was not insured because it was private land. And the court held that because the MIB is an emanation of the state, the motor directives are directly applicable to the MIB, and therefore they ought to have covered the vehicle, even though it was on private land. And so Mr. Lewis succeeded in the claim. And then we had Collier and Shooker, which was a case, again, the passenger knew the driver, not the vehicle, was uninsured, and so it wasn't covered by the Road Traffic Act, but should have been under the Verneuil style of liability, and that claim succeeded as well. And that was as recently, as you see, as last year. So we've had various criticisms of our domestic legislation from various courts and domestically since Verneuil came out. And that's the style of liability we're talking about. People who are injured on private land, people who are injured by motor vehicles that are not covered under the Act, mobility scooters and that kind of thing, ride-on lawnmowers, that type of thing. So then the government commissioned this report from the Government Actuary Department. And it's quite, if you read the reports, I have no, it will amaze you to learn, I've got no criticism of the GAD reports, because they actually say, look, we've used various ranges of figures. If you use some figures, you get this result. If you use other figures, you get this result. But you can save something like £2 billion a year using the figures provided by the motor insurance industry by not allowing for Verneuil liability. So by not making motor insurers insure vehicles on private land, there is a possibility of saving £2 billion a year. And that's where the government's announcement that each and every driver could save £50 on their premium every year came from. The first thing first point to make about that as a lawyer is you're not saving money. You're not saving motorists £50 on their premium because they don't already pay the £50 on their premium. You're just stopping it from going up £50 on your own analysis. And the £50 per premium is predicated, as I say, on this £2 billion figure, which suggests that people falling off ride-on lawnmowers and getting run over by them are going to be so prevalent that it's going to cost insurers £2 billion a year. Seems to me that's pretty unlikely, actually. I don't think there are that many accidents involving mobility scooters or private land. And actually, the insurers don't think that either. And the reasoning behind the figure of £2 billion a year is fraud. So motor insurers are saying fraud in this country is so prevalent and people are going to make so many fraudulent Verneuil-style claims that we can't afford to ensure Vnuk-style liability. So the policy behind the decision that the government made to bin Vnuk is that claimants are fraudsters. They cost defendant insurers billions of pounds a year. These claims are not well-founded, and we should not insure any of them. So the people who are not fraudulent suffer because of these huge numbers of fraudulent claims. That's the policy. And it's also the policy behind the whiplash reforms. And it seems to me, if you've read the article, you know that my response to that is, well, if that's right, if there is that much fraud around, that's something we really do need to stamp down on, you're right. But I'm not sure it is right. And I've not actually seen the figures that underpin this suggestion that 80% of claimants are fraudulent. You know, we hear a lot in gastric illness cases that most of them are fraudulent. And yet to see any hard evidence of that, actually. I appreciate it's a difficult thing to prove, but it seems to me that, if that is going to be the policy behind government decisions on whether to bin legislation or not, then we may as well just do away with the entire compensatory regime, because if that works for whiplash and it works for gastric claims and it works for catastrophically injured people on private land, because they won't be able to recover either, people who clearly aren't fraudulent, then doesn't it work across the entire board of the entire law in personal injury? And beyond, actually. If everyone in the nation, or if such large numbers of people in the nation are fraudsters, then why do we compensate any of these people at all? And so it seems to me that that's something that ought to be challenged. Oh, I've got a question. I was mid-rant there. So what you're saying is there's a big market for LVI accidents between tractors on farms that we're all missing out on. That is exactly what I'm saying. But the problem you've got is that, yeah, there's a huge market for fraudulent accidents between tractors. And I guess they would all be pretty low velocity impact, given the nature of it. And people are crashing combine harvesters into each other all the time. The problem you've got is it's not a lucrative market, because as matters now stand, they don't have to be insured. So there's no insurer answering those claims. But there could have been, you know, if the government had not binned Vnuk or decided to bin Vnuk, then yeah, you could have been in with a great new way of making huge quantities of money from farmers falling off tractors. That's exactly what I'm saying. There's going to be a general review of legislation. What's it going to mean? Will they bin other legislation? If they will bin other legislation, are they going to do away with all consumer protection legislation? If the logic of Vnuk is going to be applied across the board, does that mean that unfair contract terms are going to be binned? Does it mean that other consumer protection legislation in relation to food safety and matters of that kind, hygiene, is going to be binned? Only time will tell is the answer to that. And the big question, I think, is, are we going to diverge further? Because binning Vnuk is a divergence. It means, whatever that means, if it means, I don't know, just not extending, not amending the Road Traffic Act, does it mean riding the case law that we've got, this body of case law that I was telling you about? Does it mean just doing something else? Does it mean amending further? We don't know what binning means. But will the same considerations apply? Is the legislature moving away from a compensatory regime? Because at the moment in the English courts, our personal injury legislation is intended to compensate fully and you know, 100% and no more. But we seem to be moving away from that. And I think that's something that is a matter of policy that we ought to be discussing, whether we think that that's a good idea or not. Should we move away from the compensatory regime? Maybe we should. Maybe it is too expensive. But it's something that we shouldn't do, it seems to me, in sort of sleepwalking. It's something we ought to talk about before we do it as a nation. So are we going to diverge or come together? Ella, what do you think? Is there going to be, are we going to diverge? I guess in a way we have to, because otherwise there's no point leaving the EU.
Yeah. If you'd asked me a few years ago, I'd have said not much will change, we'll probably just carry on, there won't be that much of an appetite for it. But I mean, the fact that the government has managed to get so exercised about something as relatively obscure as Vnuk does suggest an appetite for diverging, for now going back and looking at retained law, making changes. So I suspect we may be diverging more than I had expected.
Yeah, it certainly seems that way. And I think the Vanook issue was a kind of, it's an opportunity for the government to lay a marker down. We have got Brexit done. We have left. It is going to be meaningfully different. But actually, the person who's catastrophically injured on private land through no fault of their own, because don't forget, we still have a fault-based regime. You still have to prove your case. Is going to suffer for it. Rather like the Legault point, it looks like political posturing to me.
I also find it a bit unlikely that there was ever going to be this significant amount of fraud, given that I suspect ordinary people would have had no idea what the Vanook decision was or what it meant until the government had put out press releases about how they were going to bin it. So I don't think there was a market of fraudsters there that were ready to tap in on this obscure point.
Well, who knows? Because after the backlash reforms, they've got to go somewhere.
Well, I mentioned in the chat, I'm just annoyed that I still pay road traffic insurance at all. Given that the government says they're saving me £50 on this, £30 on the whiplash, at what point do we just get below zero?
Well, you'd think, wouldn't you? But I do remember when Lord Folkes was asked a question about this when he was junior minister for justice, about where the savings were in our premiums. And he was very, very cagey about it because we don't seem to have made any.
No.
And I rather suspect the same is going to be true of the Vanook liability.
Our
rant didn't take too long. We've only got 3 minutes left in the hour. If anyone would like to ask any questions or set me off another rant, not you, Paul, not you, Chris.
We have had a contribution from Tom Yarrow, bailing us out with his Brexit wisdom.
Oh, fantastic.
The question about the bilateral treaty with the Republic of Ireland. He says he's not sure there is one. It's possible because he thinks that Ireland has derogation from the EU competence tenure on this, as does Denmark. There are historical agreements with France, Germany, Italy, Netherlands from the pre-EU days, but all likely void under the VCLT because of the EU. So there you go, that's Tom Yarrow's wisdom on that.
Really, he ought to be giving this seminar. I don't know giving this, Tom, instead of attending it. Okay, so we've had a question. If you could get rid of any EU law, what would it be? Easy peasy. I know the answer instantly. GDPR.
Oh, yeah.
GDPR, without shadow of doubt. We were talking the other day about doing a database of experts for the use of the team, of people that we thought were really good experts, foreign lawyers, that kind of thing. We decided we couldn't do it because we couldn't use their data in that way. It seems to me that that is absolutely ridiculous. I may have been reading too many editorials from the Daily Mail, but GDPR seems to me to be the most expensive waste of time of anything to come out of Europe. So GDPR, easy. Tom, what would you get rid of? You know more about EU law than most. Tom wouldn't get rid of any of it, I don't think. He's become completely naturalised.
I mean, I would love to give some other contribution, but I think you've just absolutely nailed it with GDPR. I think you could set me off on another hours-long rant on GDPR.
Well, I mean, GDPR actually is a growth industry, I think, and not because of frauds. I mean, this is what's so peculiar, that if you suffer a life-changing injury on private land, you can't be compensated. But if someone kind of accidentally mentions your name in the wrong place, you're compensated without proof of fault or intent or any kind of loss at all. So it does seem to me to be slightly mad.
Well, my poor husband is a data protection lawyer and very kindly prepared my privacy policy, all the documents that I needed for me, and yet still seems to have all my rants directed at him about you people have made my business so hard to operate.
Oh, it's all right for you. I mean, it is very, very time consuming and costly. Yeah. Ah, here we are, George. I was wondering where you were. It's well known from Pandya under Greek law, if a claim has not been served, doesn't exist for a defendant. Does it make sense that the claim suddenly served post-Brexit? For how long an insurer must maintain his team on UK claims? There is how the Greek service provisions and the UK or the England and Wales service provisions dovetail is really, really difficult. I think, for what it's worth, I think Pandya's probably wrong, but no one listens to me, so that's of no use to anyone. For those who don't know, under Greek law, you in order for a claim to have been issued, it's got to have been served as well, if you see what I mean, and then you do it retrospectively. And that in Pandya, that was held to be a matter of substance as opposed to procedure. Now, I think that's wrong, because I think serving things is a matter of procedure classically, but as I say, nobody listens to me. So it's like Greek, you need to be slightly careful with serving Greek proceedings. You're right to point that out, George. The service of proceedings under the implementation provisions under the Withdrawal Act is, however, dealt with under domestic law, and Tom will give me chapter and verse on the regulations about this. It's the 2019 amending regulations, I think, which gives you a definition of when something is issued, and it is when it is received by the court. So it's not when it's served, even in Greek cases, probably, although it doesn't mention them. But Pandya doesn't sit with that very easily, I accept. And the supplementary question for how long must an insurer maintain his team on UK claims? Well, they should all have been served by now, or by the end of June. So you ought to be able to see what you've got relatively soon. That said, I am aware of quite a large number of claims which were issued very, very close to exit day, I mean, between Christmas and New Year. And in relation to some of those, they've not yet been served, and applications are being made to extend the lifetime of the claim form. So you would have thought that most of these, you would have hoped that most of these have been served, but actually there's quite a lot of them still out there, I think, that haven't been served, and where applications are going to be made to extend the lifetime of the claim form for another 6 months. So you may be getting more in up until the end of the year, and then you'll know what you've got. And of course, those will then be subject to what we were talking about before, to challenges on whether or not it was right to extend the lifetime of the proceedings. Anonymous said 10 days service is procedural in the UK and Greece, it's a matter of law. And that's the, that is the distinction in the Pandya case. That's right, but I think that's a bit circular, because it's procedural in the UK and it's the UK court considering it, so it ought to be procedural. But as I say, that's not the answer in Pandya, but that is the thinking, that's the rationale in Pandya, yeah.
Tom Yarrow has confirmed that he does love all EU law.
Of course he has.
But more helpfully, that it's and Judgments Amendment EU Exit Regulations 2019, Regulation 95.
There you go. I told you he'd know. And I was right about the year as well. So, and I was right that he loves all EU law. And Pandya has recently been reconfirmed. Yeah, that's right. In the Stewart's case, whose name escapes me. I know that's not helpful. Tom will know the answer. Right. Any other questions? Oh, and Emma's going to be very cross with us if we don't mention week after next. Yes. Excellent, Ella. Johnson. Yes. Thank you, Chris. I do know these things. I have a vague anyway, or I know where to find them, and that's the important.
Yeah.
Yes, it was. You're right. It's reconfirmed in the Johnson case. Yes. Now, don't allow me to get distracted by the matter in hand from saying what I ought to say about Roberts and Henk will be giving a reminder of the basics on occupiers' liability on the 10th of June, and this one is at 1 o'clock, not 12 o'clock. Yeah, and it's reassuring to see that Chris agrees that Pandya is wrong. All right-thinking people do, I think.
Yeah, I do.
Well, there you go then. If all of us,
it's not evidence.
3 lawyers in the room, we all agree, it must be true, right? Okay, if no one has any other questions, I think that wraps it up. And I actually feel the better for that rant.
Good.
These things are just therapy sessions for me. We should have them once a week with just me ranting for 2 hours, it would be. Oh, of course you can ask another one, George. Pro-Pandya. Nick Parkinson's pro-Pandya. There's something wrong with you. There is just no good defence of the reasoning behind Pandya, given that service must be classically a procedural issue, Nick. Mute, Nick. Sorry, George is thinking about his question. We've not had a Darius question yet today. I wonder where he is. I hope he's all right. Translations. Greek or English translator? Ooh. Okay, so if you're translating a document into Greek, then it ought to be done by a Greek translator. I don't think it matters, actually, does it?
You would have thought just a competent translator is the key.
Yeah. Yeah, I don't think it matters one way or the other, does it? As long as it's a certified translator.
Yeah.
So they're a member of a certified body and they can certify. Under Greek law, it must be someone who's accredited in Greece. Well, if I were you, then I'd use a Greek accredited person because we don't mind. The English courts don't mind. And I guess someone who's accredited in Greece is more likely to be a competent Greek translator than someone who isn't. But yeah, as long as they're accredited, it doesn't matter, and competent. See, Greek law is full of these pitfalls, as I know to my cost. Right, any other questions? Or shall I go and make a cup of tea and have a calm down? Okay, good. Well, it's lovely to see you all. I feel like we haven't seen you for a really long time. But yeah, as I say, we'll be back on the 10th of June, although I won't be ranting, but I may be asking ranty questions. So there's that to look forward to. Lovely to see you, Ella.
And you. Thank you all.
See you soon.